Convener, I'm afraid that once again we're making bad law by the way that we're rushing this through all of the stages of legislation today. And I'm astonished that so few members in this place seem to read the business pages of any decent newspapers so they could understand that interest rates are not simply rising here but across the entire advanced global economy. This amendment, which is number 34, and I also speak to number 44, is on the basis that I believe that universities should be able to evict students who have breached tenancy agreements. Tenancy agreements will often contain terms and conditions to ensure students aren't disruptive to others and aren't committing antisocial behaviour. University Scotland has specifically made it clear that universities have to retain the power to remove students from accommodation where they pose a risk, violent or sexual, to other students. They highlighted this in their briefing as a particular problem in university halls. Yes, I will.
I wonder if the member might recognise that the briefing came before the bill was fully published.
Stephen Kerr.
I do recognise that, but nevertheless the briefing is still pretty largely relevant, and particularly in relation to this amendment, because the bill states that students can be evicted for a relevant conviction, which means an offence committed by using or allowing the use of the let property for an immoral or illegal purpose, or any offence which was punishable by prison. The bill defines antisocial behaviour as doing something which causes or is likely to cause the other person alarm, distress, nuisance or annoyance. But this may not cover all students who pose a risk to others, and so the reason that I'm bringing this amendment is that I believe, as does University Scotland, that it is necessary to give universities the power to evict students who pose a risk to others. This is a very reasonable and reasoned amendment. So, my amendment will simply allow institutions the ability to make judgments on evicting people from purpose-built student accommodation. And for me, this amendment is primarily about trust, and it's about protection. It's about protection of young people, some of whom can be very vulnerable as they take their first tentative steps away from home. Maybe some of us in this chamber can still remember our own sense of vulnerability when we first went to university, probably the first time that we had stayed away from home on an extended basis. And the other thing is, and I would be astonished if someone disagrees with this, Scotland's universities take their duty of care for their students very seriously. And the uniqueness of purpose-built student accommodation should be recognised by the Minister in the context of the amendment that I'm proposing. If members think that universities don't move heaven and earth to protect their students, I would suggest that members spend some time with Scottish universities. There are members here who have had their entire political ambition shaped by their experience at university. And this is an occasion, I hope I can say this with a recognisable authenticity, for us to put down our megaphones and to rationally consider what this amendment does in terms of protecting students. The behaviours covered by the briefing that University of Scotland has provided goes beyond the criminal antisocial behaviour that's mentioned in the bill. I'm also pretty sure that all of us, as members of Parliament, will have had experience of dealing with cases where constituents have felt threatened by someone whose actions are not criminal, but nevertheless pose a risk to others. And this amendment is about risk and protection. And the universities in Scotland need to have the freedom to be able to evict people who are posing a risk to others. This happens now and is handled discreetly and with great care by university accommodation managers up and down the country. It's subtle, and it allows professional housing managers to take action to prevent problems before there is a criminal accusation, a criminal charge and a criminal conviction. This is sensible management. This is a sensible approach to often a very difficult and sensitive problem. What this bill does is remove the ability of those professionals to do their job in the interests of all of the students in their care. And my amendment would put a reasonable and controlled amount of responsibility into the hands of those who are closest to the issues that I'm describing that require sensitive management. Now, I am very firmly of the view that this legislation that we're rushing through this Parliament this week is going to be a disaster in terms of increasing homelessness and in terms of choking off the supply of available property for accommodation for rent. But let's put that aside for a minute. Threats, neighbourhood disputes, disruption, drug-taking, loud parties, abusive behaviour in our communities are a scourge. And they are responsible for so much misery. There is no need for that to be tolerated within the confines of purpose-built student accommodation. 700,000 of our fellow Scots report having been victims of antisocial behaviour in the past 3 years, according to the community safety group Resolve. To protect the minority of perpetrators, the government seemed to be prepared, in the context of purpose-built student accommodation, the government seemed to be prepared to be content to leave the lives of the majority students in halls miserable, because nothing can be done. So it's imperative, convener, that we don't allow this to happen. It is imperative that we trust the professionals. It's imperative that we give them the power, the flexibility to run the institutions that they know best how to run, to protect the people that they know how best to protect. So, as I say, in discussing this amendment, it simply is I think, a common-sense-based proposal that allows universities to operate without this restrictive and disproportionate piece of legislation which will restrain them and leave our young people without adequate protection.